Thank you very much, Mr. President. For centuries, the people of Afghanistan have gathered to administer justice in jirga and shura in accordance with ancient traditions and the Holy Quran. Justice is at the core of religious and traditional beliefs of Afghans. For 4 decades, Afghans have endured one armed conflict after another. These have left too many Afghans mourning the loss of their mothers, fathers, brothers, and sisters. When Afghanistan joined this court in 2003, the Rome Statute system became part of Afghanistan's legal framework and presented a set of legal remedies that Afghans have a right to access. Today, after a preliminary examination that lasted 11 years, followed by 17 months during which the pre-trial chamber considered the prosecutor's request to start an investigation, the court is holding its first hearing on the Afghanistan situation. It concerns issues of critical importance, not only to the victims that we represent, but to all Afghans. It has been a very long journey for the victims until today, but today is a historic day for accountability in Afghanistan. The 82 victims that we represent belong to various Afghan groups. They live in diverse parts of Afghanistan, and they speak different languages. They are victims of crimes allegedly involving different actors. Whatever their differences, they are united in their wish for an investigation to begin promptly into the crimes committed against them. We are here to challenge a decision that has extinguished all of their rights under the statute and has caused enormous damage to any hopes they have for justice and accountability. Many of the victims we represent are mothers with children. Your Honour's decision in this case will in no small way define whether those children grow up in Afghanistan characterized by the rule of law or by a culture of impunity. The interests of the victims and the prosecution do not always coincide. We're all agreed on that. It is critically important that victims have an independent right to appeal a decision that presents a clear and extreme danger to their rights. It is also important that victims can present their own grounds of appeal when appealing such a decision. The prosecutor has many issues to consider: the resources available to it and its position in other situations. It has to balance its obligations to different groups of victims within and across situations. These competing considerations were brought to the forefront by the prosecutor herself in an address to the Assembly of States Parties 2 days ago on the 2nd of December 2019. She said that, quote, "One key question that my office will need to tackle in the coming period is the reality that a number of preliminary examinations will likely progress to the investigation stage, but we will not have the operational capacity to absorb them all. As such, we are considering how prioritization might apply across different situations," unquote. In contrast, the interests of the victims are limited to one situation, the Afghanistan situation. The legal representatives of the victims are under a duty exclusively to represent their interests of their clients in this situation. They have no other interests to defend in accordance with their obligations under the Code of Professional Conduct for Counsel. I will now address Your Honour's questions under groups A and B. I will begin by addressing together questions AA, AB and AC, which concern standing to appeal a decision. The Rome Statute recognises the interests, views and concerns of 4 principal actors. Those are the prosecutor, the defence, whether as suspect, accused or convicted person, states and victims. The statute allows these 4 actors to defend their interests and to express their views and concerns through various procedures at different phases of the proceedings. Interlocutory appeals are, of course, regulated by Article 82, and all interlocutory appeals, regardless of whether they fall under 82.1a or 82.1d, may be appealed by, quote, either party, unquote. An ordinary reading of either party does not expressly limit interlocutory appeals to any particular one of the 4 parties I identified. Articles 18 and 19, read together with Article 82.1, make it clear that at least 3 parties, that is to say, an accused or person for whom a warrant of arrest or summons has been issued, a state in certain circumstances, and the prosecutor, can be considered a party for the purposes of 82.1. But the expression either party is not limited to those 3 parties, nor is Article 82.1a limited to decisions under Article 18.4 and 19.6. The Trifter commentary recognises that, quote, other decisions that are potentially appealable under Article 82.1a include, for example, those under Article 15.4, close quote. The presence or absence of an express right to appeal is not determinative of standing. Some provisions, such as Article 18.4, expressly provide for a right to appeal for a state. Article 87.7, on the other hand, does not provide for an express right of appeal for a state referred to the UN Security Council or to the Assembly of States Parties. But nevertheless, in the al-Bashir case, Jordan appealed an 87.7 decision on the basis of Article 82.1d, and the appeals chamber quite properly, if I may say so, considered the merits of that appeal. In determining whether one of the 4 principal parties in the statute have standing to appeal a particular decision where no express right of appeal exists, I submit that the appeals chamber should consider 3 factors. First, whether the statute recognises the participation of the applicant at that stage of the criminal proceedings. Second, whether the impugned decision is highly prejudicial to the interest of the applicant. Third, whether hearing the appeal will result in unfair prejudice to any other party. All 3 of those requirements are satisfied here. First, the pre-authorization stage, which is addressed in Article 15 and Rule 50, only envisages the participation of the prosecutor and victims. The Appeals Chamber recognised in its decision of the 24th of October 2019 in this situation that Rule 53, quote, highlights the importance of victim participation in the procedure for authorization of investigation, close quote. Second, the impugned decision was extremely prejudicial for the victims. A decision denying authorization affects every victim of every crime of every potential case arising out of the situation. Where victims are denied an investigation, they are, without exaggeration, denied everything. All of those victims in all cases in the entire situation are denied the realization of their rights, recognized by this court, to truth, justice, and reparation. Now, Mr. Guarilla, in his submissions, made a distinction between victims of a case and victims of a situation. But the impugned decision here is more consequential to the victims of a situation than a decision which might, for example, acquit all accused in one particular case, or a decision to award no reparations or a derisory sum of reparations in a particular case. Those decisions apply to a specific case. They don't apply to the entire situation. So in our submission, a decision to deny investigation in a situation is in fact the most consequential decision for victims. There's no decision which can be more prejudicial to their rights. Third, there is no unfair prejudice to any other party should the appeals chamber recognize the standing of victims. In particular, there's no unfair prejudice to the prosecution. The prosecution's submissions concerning its floodgates argument have no merit. In its 22nd October response to the appeals by the victims, and again today, we've heard the prosecution refer to the possibility of NGOs, states which don't have an interest in the proceedings, potentially even members of the public with a grievance against a decision of a pre-trial chamber coming along and clogging up the appeals system and wasting Your Honour's time. That is simply an entirely overstated and misconceived argument. The prosecution itself, in its 2019 to 2021 strategic plan, has restated its position that, quote, under the Rome Statute, victims are actors of international justice rather than its passive subjects, close quote. They fully meet all requirements of a test for standing which the prosecution itself asked the appeals chamber to consider. And I refer to our submissions on this point in our 29 November 2019 response to the amici curiae. The victims are not strangers to these proceedings, nor do they suggest that strangers to the proceedings be allowed to appeal as of right or indeed at all. Your Honours, I turn now to question A.D. In this question, Your Honours referred to the fact that victims have an internationally recognised right to an effective remedy and access to justice under Article 21.3. You've asked if this includes a right to appeal the impugned decision. And we say, yes, it does. The appeals chamber, Your Honours, are required by Article 21.3 to interpret and apply every article of the statute, including 82.1a, in accordance with the rights which Your Honours identified. The victims here would very well pursue another remedy if they had one. They don't have one. Over the course of its 11-year preliminary examination, it became clear to the prosecutor that states in a position to exercise jurisdiction are either unwilling or unable to do so. The pre-trial chamber reached the same conclusion. We submit they were right about that. The recent submissions presented by the government of the Islamic Republic of Afghanistan show only that it remains unable to effectively investigate or prosecute. This applies even if Your Honours accept that it is willing to do so, which is an open question. The only jurisdiction in the world, without exaggeration, that can offer the victims a prompt and impartial investigation into the brutal crimes committed against them is this court. The only way the victims can exercise the right to an effective remedy is to appeal the impugned decision. I'd like to address very briefly a point raised by my learned friend, Mr. Guarilla, that however desirable victim standing might be, we need to leave that up to the Assembly of States parties. And I would suggest that that is not well-founded, and it is not consistent with the purposive approach which this appeals chamber has taken to the statute. Your Honours, not necessarily this bench, but the appeals chamber has interpreted the statute purposively on many cases. The no case to answer procedure appears nowhere in the statute or rules of procedure and evidence, and yet it now exists at this court. The duty to be present at trial is absolutely clear in the statute, and yet it has been recognised in Ruto that an accused can actually be absent for very large portions of his or her trial. The lack of ability to issue a binding order to a witness to appear to testify was one of the great weaknesses of the Rome Statute, and the appeals chamber cured that weakness. And it also cured the absence of a duty on a state to ensure that a witness appears to testify. The stay of proceedings which arose in Lubanga proceedings, that doesn't appear in the statute either. So there are many cases where this appeals chamber has upheld purposive interpretations of the statute. The statute is a living document, like the European Convention on Human Rights, and it should be interpreted as a living document intended to provide realization of the rights of those of the victims. Now, Your Honours, I want to turn now to the questions on jurisdiction. In response to question BA, the answer we submit is yes. There's no binding jurisprudence, obviously, on the question of whether a decision to deny investigation is a decision with respect to jurisdiction. The closest we have are some decisions which are essentially decisions about admissibility. The appeals chamber's decision in the Kenya situation emphasises that the right to appeal a decision on jurisdiction or admissibility is intended to be limited to rulings specifically on the jurisdiction of the court or the admissibility of the case. The appeals chamber also cautions that it's not sufficient that there is an indirect or tangential link between the underlying decision and questions of jurisdiction. Now here, the trial chamber made determinations specifically on the jurisdiction of the court. The link between the underlying decision and these questions of jurisdiction is not indirect, it is not tangential, it is direct. This is for three reasons. First, the decision deprives this court of the possibility to exercise jurisdiction over any cases which might arise in the Afghanistan situation. That's very far-reaching. Every chamber of this court is deprived of jurisdiction. The prosecutor is deprived of investigative jurisdiction into all crimes in the situation. Second, the decision contains serious errors concerning the territorial jurisdiction of the court over torture, and indeed that applies by extension to all war crimes, requiring the court to find that the conduct, quote, took place in the context of and was associated with, unquote, an armed conflict. And that applies, of course, to every war crime in Article 8. Third, the pretrial chamber erroneously attempted to impose limits concerning the scope of the court's jurisdiction in any authorized investigation. Its limitation on the scope of the investigation to incidents specifically mentioned in the prosecutor's request is a determination with respect to jurisdiction in three ways: temporally, territorially, and in matters of substance. Mr. Guarilla referred to the decision of Judge Eboe Osuji of the 2nd of September 2019, the Comoro situation. I respectfully agree with Judge Eboe Osuji's analysis there. It's important that the appeals chamber retains control over what is and is not a decision with respect to jurisdiction. Your Honours, do not have to be totally hung up on exactly what the operative part of the decision might say, whatever that operative part might be. In this case, the operative part certainly deprives, as I've submitted, the court of jurisdiction over every case in the Afghanistan situation. That's its effect, that's the nature of the decision. Now, Judge Eboe Suji has emphasized that the deciding chamber can't be that one which decides whether it's a decision on the exercise of jurisdiction. It can't control the appeals chamber's ability to consider that decision as really being with respect to jurisdiction. That cannot be right, he says, and we respectfully agree. A decision with respect to jurisdiction is, on a common sense application, the kind of decision which should be subject to appeal as of right. It is an incredibly consequential decision for the prosecutor, for the victims. It is something which should be subject to appellate scrutiny. It's not something minor, such as whether the parties should have to produce an in-depth analysis chart or something like that, which has taken up appellate scrutiny. I turn now to question 8B. In response, we submit that determinations regarding territorial or personal jurisdiction over Article 12 or decisions regarding the exercise of the court's jurisdiction under Article 13 are indeed decisions with respect to jurisdiction. Articles 12, 13 and 15 all fall within Part 2 of the statute headed Jurisdiction, Admissibility and Applicable Law. They all fall within Chapter 3 of the Rules and Procedure of Evidence. The heading of Chapter 3 is Jurisdiction and Admissibility. I submit that that header was chosen deliberately. One of the sections of that chapter relates exclusively to initiations of investigation under Article 15. The chapter also covers Articles 12 and 13. So at least if using those as sources, we can see that decisions with respect to jurisdiction and admissibility should cover decisions under 12, 13 and 15. Now, it's important that the appeals chamber, and I'm sure there'll be no dispute about this, always does and always must retain a discretion to reject an appeal which is an abusive process, even if it might technically fall within Article 12, 14, 15 or any other article. An appeal filed for frivolous or vexatious reasons, such as one of negligible prejudice to the applicant, or one which is unfairly prejudicial to another party, can and should be rejected in limine on a case-by-case basis. In my submission, Your Honours, and every appeals chamber has always had that power. And over the years since this court became operational, over 15 years ago, there really has been a very low level of vexatious applicants, and the court has tools at its disposal to deal with vexatious applicants, and it should use those tools. Correcting errors concerning the court's jurisdiction over Rome Statute crimes at an early stage of the proceedings is consistent with the approach of the appeals chamber in Ntaganda on the 22nd of March 2016, where it twice emphasized that, quote, issues as to the court's jurisdiction should be resolved as early as possible in the proceedings. It's absolutely correct for the appeals chamber here to let states parties understand from an early stage the extent of the court's territorial jurisdiction in the Afghanistan situation. It's pragmatically the right thing to do, to clear the air for all parties, for all states, in relation to major questions of jurisdiction at an early stage in the situation. There are, let's face it, not going to be very many appeals against decisions to deny authorization to the prosecutor to initiate an investigation. We're here in 2019. This is the first time this has actually arisen. How many times is it going to happen in the future? Probably not that many. It's the kind of things which should be subject to appeal as of right. It would be a tremendous error to limit appeals on jurisdiction to decisions in relation to Articles 18 and 19 only. I turn now to question B.C. Our response to this, and this is my final submission, is that when the pretrial chamber limited the scope of the investigation, this was a determination with respect to jurisdiction. Each Article 15.4 authorization decision is required to examine jurisdiction in two ways. First, it's required to examine the court's temporal, territorial, and substantive jurisdiction over the alleged crimes. The admissibility of the situation is another analysis. And then second, it has to re-enter the jurisdictional debate and satisfy itself that it is ordering an investigation on suitable temporal, territorial and substantial jurisdictional areas.
Excuse me, Council, you have 5 minutes left.
Thank you very much indeed. So those are two major areas of jurisdictional analysis, each of which requires analysis of temporal, territorial and substantive jurisdiction, which must be carried out in each decision on an application for authorization to investigate a situation. A perfect illustration of this is the Article 15 decision concerning Myanmar of 14th November 2019, where that pre-trial chamber strikingly took a very different approach to the Afghanistan pre-trial chamber. In their decision, the two decision sections on jurisdiction took up about 60% of the pages of the decision itself. It plainly was a decision with respect to jurisdiction. Nobody can reasonably insist that it was not. And if the Myanmar-Bangladesh decision was a decision with respect to jurisdiction, so is every other pre-trial chamber decision which authorizes or refuses to authorize the commencement of an investigation. That ends my submissions. Thank you very much, Your Honours.